The Zambia Law Development Commission wishes to inform members of the public that a simplified version of the Constitution of Zambia Amendment Act Number 7 of 2025 has been prepared in Zambian Sign Language to facilitate wider public understanding of the constitutional amendments. Members of the public are advised that the simplified version is intended solely as an explanatory aid and should be read together with the official text of the Constitution of Zambia Amendment Act Number 7 of 2025. Copies of the simplified version may be accessed electronically through the official website of the Zambia Law Development Commission. The Commission encourages all citizens, stakeholders, civil society organizations, professional bodies, and other interested persons to familiarize themselves with the contents of the Act and engage with the simplified materials made available in the various languages. The Commission remains committed to promoting public awareness, accessibility, and understanding of Zambia's laws through the provision of legal information in languages that are widely spoken across the country. Short title. This law is called the Constitution of Zambia Amendment Act 2025. It makes some changes to the current Constitution of Zambia. Amendment of Article 47. This amendment introduces a mixed member proportional representation electoral system for electing MPs. Under this system, some MPs will continue to be elected through the first-past-the-post electoral system. In contrast, other MPs will be elected through a proportional representation electoral system for seats specially reserved for women, youths, and persons with disabilities. Under the proportional representation electoral system, the seats reserved for women, youths, and persons with disabilities will be distributed by the Electoral Commission after the election among the political parties. Each political party will get a number of these seats based on how many votes it received during the election. The method the Electoral Commission uses to distribute seats under the proportional representation electoral system will be provided in a separate law. The rest of the constitutional provisions on the electoral system remain the same as they are in the Principal Act. Amendment of Article 52. Article 52 of the Constitution is amended to clarify the process for filing nominations and handling certain situations involving candidates in elections. The amendment requires anyone seeking election as president, member of parliament, mayor, council chairperson, or councillor to submit nomination papers together with an affidavit confirming that they meet the qualifications for the position. These documents must be filed in the manner and at the time set by the Electoral Commission. The amendment also gives the Electoral Commission greater authority not only to hear, but also to determine matters relating to nominations. The provision further explains what happens if a candidate withdraws is disqualified or dies after nominations have closed. If a candidate resigns or is disqualified by a court, they will no longer be allowed to contest the election, but the election will still proceed as scheduled. However, where a candidate sponsored by a political party dies before the election, the Electoral Commission must cancel the election and allow the political party to submit a new candidate, after which the election must be held within 30 days. Amendment of Article 58. Article 58 is amended to provide the number of constituencies in Zambia must match the number of constituency-based seats in the National Assembly. Repeal and replacement of Article 68. Article 68 is amended to change the composition of the National Assembly. Under the new provision, the National Assembly will consist of 226 constituency-based members of Parliament, 40 members elected through proportional representation, not more than 11 nominated members of Parliament, the Vice President, the Speaker, and the first and second Deputy Speakers. The 40 proportional representation seats will specifically be reserved for 20 women, 15 youths, and 5 persons with disabilities. The amendment also limits the number of nominated members of Parliament to no more than 5% of the constituency-based seats. The purpose of the provision is to increase inclusion and representation of groups that are often underrepresented in Parliament, while also clearly defining the structure and size of the National Assembly. Repeal and replacement of Article 71. This provision sets out the requirements for a valid nomination in elections. A person contesting for a constituency-based parliamentary seat must pay the required fee to the Electoral Commission and must also be supported by at least 15 registered voters from the constituency where they are contesting. For seats under the proportional representation system, the nomination will only be valid if the prescribed election fee is paid to the Electoral Commission. This provision, therefore, establishes the basic conditions that candidates and political parties must meet before being allowed to participate in an election. Amendment of Article 73. Article 73, sub-article 2, is amended to clarify that the High Court can both hear and decide election-related matters. Amendment of Article 81. Article 81 is amended to provide that Parliament will officially end 90 days before the next general election, but members of Parliament will continue to be regarded as serving until the day before the election. Amendment of Article 103. Article 103, sub-article 2, is amended to clarify that the Constitutional Court has the power not only to hear matters, but also to make decisions on them. Amendment of Article 116. The provision introduces a new ground, which provides that a minister's office will become vacant 90 days before a general election. This new ground overrides other existing grounds that result in the office of a minister becoming vacant in Article 116, Sub-Article 3. Amendment of Article 117. The provision introduces a new ground, which provides that a provincial minister's office will become vacant 90 days before a general election. This new ground overrides other existing grounds that result in the office of a provincial minister becoming vacant, Article 117, Sub-Article 3. Amendment of Article 149. The provision introduces the word electoral before the word boundaries in the provision to clarify that the Electoral Commission is responsible for describing boundaries used for electoral purposes, such as constituencies or wards. Amendment of Article 153. Article 153 of the Constitution is amended to clarify who will form the council. A council will now include elected councillors, members of parliament from each constituency within the district, the mayor or council chairperson, and up to 3 chiefs chosen from the district. The amendment also states that council members will remain in office until the day before the next general election. Repeal and replacement of Article 154. Article 154 is repealed to provide that every council will have a mayor and a deputy mayor, or a council chairperson and deputy chairperson. It also sets the qualifications for becoming a mayor or chairperson, including citizenship, being at least 21 years old, being a registered voter, and having a Grade 12 certificate or equivalent. The amendment further provides that mayors and chairpersons will be elected directly by voters during council elections, while councillors will choose deputy mayors and deputy chairpersons from among themselves. Amendment of Article 159. The provision introduces the words "and determine" after the word "heard," clarifying that once an election petition to nullify the election of a councillor is submitted to a local government elections tribunal, the petition must not only be heard, but also determined within 30 days. Amendment to Article 176. The provision changes one of the qualifications for who can be appointed as secretary to the cabinet from the current 10 years of experience as a permanent secretary or an equivalent rank to 5 years. Amendment of Article 178. The provision deletes paragraph B, which states that the office of the Attorney General becomes vacant if another person assumes the office of President. Amendment of Article 179. The provision deletes paragraph B, which states that the office of the Solicitor General becomes vacant if another person assumes the office of President. Amendment to Article 266. Article 266 of the Constitution is amended by A. The deletion of the definitions of adult, by-election, child, election, general election, and term, and the substitution, therefore, of the following in the appropriate places in alphabetical order. Adult means a person who has attained the age of 18 years. Child means a person who is below the age of 18 years. Election means an election to the office of President, Member of Parliament, Mayor, Council Chairperson, or a councillor. General election means elections to the office of President, Member of Parliament, Mayor, Council Chairperson, or a councillor when held on the same day. Term means a period commencing when Parliament or a council first sits after a general election, ending when Parliament is dissolved, except as is provided under Article 106. And youth means a person who has attained the age of 18 years but is below the age of 35 years. And B. The insertion of the following new definitions in the appropriate places. Constituency-based seat means a seat in the National Assembly that is held by a member of Parliament elected under the first-past-the-post electoral system, and ward-based seat means a seat in a council that is held by a councillor elected under the first-past-the-post electoral system.